Good morning, members of the tribunal. My name is Seah, and together with my co-counsel, Mr. Ramesh Kanna, we represent the appellant, Mr. Antonio Fortuna, in today's proceedings. I'll be addressing the first two issues on appeal for 10 minutes, namely whether the appellant's statement of appeal is admissible and whether it was lawful for the appellant to refuse to hand over his handphone, and the possible legal consequences that may ensue. Mr. Kanna will address the panel on the remaining two issues for 10 minutes. We respectfully reserve 1 minute for our rebuttal. Members of the tribunal, we do acknowledge that certainty is a cornerstone for procedural matters of the court. However, overemphasis on certainty must never come at the expense of fairness and justice, particularly where a party has taken all reasonable steps to comply with the rules and yet is thwarted by forces beyond their control. Today, this panel is faced with two options. You can choose to enforce rules that results in unfairness, especially when non-compliance arose from circumstances beyond a party's control, or you can choose to respect the fundamental values of natural justice, such as the opportunity to be heard, and ensure that procedural formalism does not eviscerate real access to justice. Turning to the first issue, the appellant maintains that a statement of appeal is admissible and respectfully requests that a time limit be reinstated given the unforeseen and non-negligent technical failure experienced by its legal team. In this respect, we make three submissions. First, the attempt to file the statement of appeal was before the expiry date. Applying Rule 49 of the CAS Code, it stipulates that the subsidiary time limit of 21 days starts from the receipt of the decision appealed against. While counsel for the respondent may allege that the receipt of the decision fell on the 31st of March instead of the 2nd of April, we submit that this is wrong. Under Rule 49 of the CAS Code, interpreted in the 2013 CAS case of Dominic and Jack Cole, the word decision in receipt of the decision refers to the full grounds of the decision and not just the decision itself. While the decision was indeed published on 31st of March, if I could turn the panel's attention to the paragraph 34. We have to consider the full grounds of the decision was only published on the 2nd of April and not the 31st of March. We have to consider the dangers of submitting an appeal without fully knowing the purpose of the appeal. Firstly, filing an appeal is not free and requires a payment of CHF 1,000 as noted in Rule 38 and 64 of the CAS Code. Aside from that, the appellant first needs to consider what he is appealing. Without the full grounds of decision, he could possibly be lodging a frivolous appeal, and as the interpretation of decision in Rule 49 encompasses the publication of the full decision, we submit that 2nd of April should be the date of the receipt and not 31st of March. Secondly, the filing failure was caused by an unforeseen external impediment. While Article 32 of the CAS Code generally prohibits the extension of time limit, what the appellant is seeking is the possibility of reinstatement, which is what we are asking for this case. This is a remedy available when a party was prevented from complying due to an unforeseen impediment which made compliance impossible through no fault of their own. If I could turn the panel's attention to para 30 of the record. The appellant's legal team immediately informed the CAS, providing a screenshot confirming that their email servers had been subjected to a cyber attack which may have disrupted outgoing emails without necessarily generating delivery error messages. The right to reinstatement requires that impediment have to be unforeseeable. To illustrate, the 2023 Swiss Federal Tribunal case of B and FIFA noted that the court had rejected reinstatement sought due to a lawyer's illness because the symptoms had begun the appeal period started, rendering the impediment foreseeable. In our case, the appellant's counsel had no prior warning of the cyber attack that suddenly derailed the filing just 15 minutes before the deadline. Considering that this was a cyber attack which was outside of our control, the impediment here was genuinely unforeseen through no fault of their own. Unless I may be of further assistance on the first issue.
Just one question, counsel. So the respondent will claim that the day of receipt, is before on April or March 31st. What's your response to that?
Certainly, Mr. Arbitrator, we note that the respondent may contend that a simple decision suffices what is meant by receipt of the decision under Rule 49. But as case law has presented in a 2013 case of Dominic and Jack Cole, it refers to the full grounds of the decision and not the simple decision itself. And furthermore, on a more practical standpoint, the appellant has to first consider what he is appealing against, and the decision that is appealed is overruled is not sufficient for him to properly lodge a ground of appeal, which is required in the full requirements of the Statement of Appeal as provided in Article 32 of the CAS Code. Turning now to the second issue, we submit that the decision of the FIFA Appeal Committee should not be followed and maintain that the appellant's refusal to hand over his mobile phone is lawful and justified by fundamental rights under the European Convention of Human Rights. As noted in the 2013 ECHR case of Mutu and Peshtain, Article 6 of the ECHR can apply to cash proceedings if it applies to determination of, and I quote, civil rights and the obligation of a criminal charge. The court had recognized the suit against Peshtain involved a disciplinary procedure before the professional bodies where the right to an occupation was at stake. In that case, Peshtain was suspended from playing for 2 years. Similarly to our case, the appellant is facing a possible 5-year ban, which directly prevents him from practicing his own profession, which falls under a determination of civil rights. Secondly, Article 6 protects Mr. Fortuna from self-incrimination. Mr. Fortuna's refusal was based on his legal counsel advising that investigation into his mobile phone could prejudice his rights to defend himself before the Iridonian Public Prosecutor's Office. And protection against self-incrimination has been noted to be a cornerstone of Article 6 of the ECHR. In a 1993 European Court of Human Rights case involving Funke and France, the appellant had refused to produce his personal financial documents, and the domestic courts had initially imposed a fine and ordered him to produce such documents, if not, he'll be fined further. This was overturned in the European Court of Human Rights, which held that a right to remain silent and not contribute to incriminating oneself is a cornerstone of Article 6 to determine whether an individual has the right to a fair trial. Crucially, the court noted that the conviction was secured in order to obtain the documents that the customs believed to exist, and is similar to our case, compelling the appellant under the threat of a sanction to produce private data that could directly incriminate him in concurrent criminal proceedings constitutes an intrusion incompatible with Article 6 of the ECHR. The appellant himself has not even been fully investigated by the Iridonian Public Prosecutor's Office, as noted in Exhibit 5. The appellant's justification is based on prejudice before the Public Prosecutor's Office confirms the refusal was a lawful assertion of his due process rights. And secondly, the FDC, specifically the FIFA Disciplinary Code, limits the penalties for non-collaboration. The appellant has already faced the appropriate penalties for non-cooperation, and the FDC dictates that a substantive decision must rely on the existing file. This is noted in Article 12.5 of the FDC that states that if parties fail to collaborate, the judicial body may nonetheless reach a decision on the case file in its existing possession. This rule permits that a panel can proceed but explicitly anchors the decision of the evidence available already in the file. In conclusion, because the appellant's refusal was justified by its fundamental rights applicable, and because the FDC limits the legal consequence of non-cooperation to the existing file, FIFA must prove that a serious charge of match manipulation to the standard of comfortable satisfaction is still be met and yet it has failed to do so. Unless I may be of further assistance on the second issue.
Counsel, I have a question. So the respondents will argue that they have to maintain the integrity of the sport. Um, um, to your argument, what is your response to what the respondents will argue in that respect? For Article 6 of the European Courts.
Mr. Arbitrator, I note that my time has elapsed. If I may have a minute to answer your question.
Yes.
Thank you. So, with regards to maintaining the integrity of the sport, we have to consider the fundamental rights that the international treaty does give to athletes. And in our case, the FIFA and the CAS is bound by the ECHR, as we are located in Switzerland, and Switzerland itself is a party to the ECHR. So therefore, to answer Mr. Arbitrator's question, it's mainly between whether we have to prioritize the integrity of the sport and the fundamental human rights that does exist from a convention. And in this respect, we argue that the fundamental human rights does take precedence to the integrity of the sport. Unless I may be of further assistance on this issue.
Thank you, counsel.
Thank you, Mr. Arbitrator. I'll now hand over my time to my co-counsel, Mr. Ramesh Kanna, who will address the remaining two issues on appeal.
Good evening, members of the tribunal. My name is Ramesh Kanna and I act for the appellant, Mr. Fortuna. I have two issues before this tribunal today. Firstly, the anonymous witness statement and the anonymous email are not admissible. And secondly, the appellant has not breached Article 20 of the FDC. Now, with regard to my first submission, firstly, with regard to the anonymous witness statement, CAS imposes strict safeguards before anonymous evidence can be relied upon. Now, the leading authority in jurisprudence has held that anonymous testimony is only admissible if three conditions are met. Firstly, necessity of anonymity. Secondly, identity verification by the panel. And thirdly, sufficient corroboration. This was held in the 2017 CAS decision of FC Kairat Almaty and UEFA. Now, this is also supported by academic commentary by Mavrovanti and Reeb on commentary on the CAS code with regard to Article R57. It confirms that anonymity must be exceptional, justified by a concrete, objective threat. Now, in the present case, none of these safeguards are met. The anonymous witness statement is based on unsubstantiated fears. The witness claims they fear intimidation because of rumors that Fortuna's father has criminal connections. This can be seen in Exhibit 2 and paragraphs 5 and 6. Are members of the tribunal with me?
Yes.
However, in the 2018 CAS decision of Wada and Sun Yang, the panel held that speculative fears, such as that of rumors, without objective evidence of danger, cannot justify anonymity. And this is the case at present. Because no incidents have occurred, no threats have been given, and no supporting evidence exists, the anonymity was not necessary under the Kairat Almaty standard. Now, secondly, the witness's observations are weak, incomplete, and untestable. The witness observed the appellant stressed the night before the match and heard him say, "Dad, stop pressuring me." But critically, the witness admits he could not hear the father's side of the conversation. The panel in the 2009 CAS decision of FK Probeta and UEFA have clearly stated that evidence that cannot be cross-examined meaningfully because the context is missing cannot satisfy the standard of proof. The evidence here demonstrates stress, indeed, however not manipulation, and it's wholly uncorroborated. Now, moving on to the anonymous email, it is even weaker in that it is unauthenticated digital hearsay. The email alleges that Fortuna's father received 50,000 dodgy coins. Exhibit 3, this is visible, and attaches a WhatsApp screenshot showing Luck the Crook acknowledging the receipt in Exhibit 4. But the sender states, and I quote, "I will not reveal my identity and cannot provide more information." Under the 2011 CAS decision of Alejandro Valverde and Connie, digital evidence must be authenticated through metadata, forensic analysis, or verified origin. Here, there's no metadata, no verification of wallet ownership, no forensic confirmation of the screenshot, and no link between the alleged payments and the appellant. Now, even the Iridonian prosecutor simply stated that the father has provided access to his Dogecoin wallet, and not that any illicit transfer had actually occurred. Now, as Blackshaw Sports Law notes, anonymous digital submissions are the weakest form of evidence under the CAS regime. Finally, the comfortable satisfaction standard has not been met. Match manipulation allegations require the heightened standard of comfortable satisfaction, which is above the balance of probabilities and below reasonable doubt, to be established. And this was stated in the 2010 CAS decision of Oleg Orkiov and UEFA. Now, anonymous evidence cannot meet this threshold, members of the tribunal, as the identity is not verified and the motive cannot be tested and the testimony is uncorroborated. None of these prerequisites are met, and even if admitted, the evidence carries no probative value. Now, if members of the tribunal have no further questions.
I do have a question, counsel. So, assuming we disagree with you and decide that the anonymous witness statement and the anonymous emails are admissible, what's your position on the weight we should give them?
I understand your concern, Mr. Arbitrator. So if the panel does admit these materials, our fallback submission is that they should be given very limited, if any, weight. And I'll address this in 3 points. Firstly, they add nothing concrete to the evidentiary picture. The witness cannot give the content of the father's words, only that Mr. Fortuna looked stressed and told his father to stop reassuring him. And secondly, they are incapable of real testing. Even if anonymous evidence is formally admissible, CAS still evaluates its reliability in light of the inability to cross-examine, the lack of corroboration, and the risk of fabrication. And finally, they cannot bridge the causal gap to manipulation. At the very highest, the respondent can only take its case to say that they suggest tension between a player and his father, and that the father may be involved in something questionable. They do not show an agreement to fix the match, a financial benefit to the player, or any link of any such betting activity.
Thank you. Thank you, counsel.
Now, with regard to the second submission, the appellant submits that Article 20 of the FIFA Disciplinary Code has not been violated. Properly construed, Article 20 requires proof that the appellant directly or indirectly, by act or omission, unlawfully influenced or manipulated the cause, result, or any other aspect of the match. Neither the elements of manipulation nor those of failure to report an approach are met on the evidence. Now, firstly, the legal framework regarding this matter is that there's a high standard for match fixing that has to be met under Article 20. CAS has consistently held that allegations of match fixing must be proved to the standard of comfortable satisfaction, higher than a mere balance of probabilities. In those cases, such as the 2010 CAS decision of Oleg Orkiov or the 2009 CAS decision of FK Probera, the sanctioning bodies relied on convergence of strong evidence, intercepted calls, financial flows, witness statements, and even findings of state courts. Academic analysis of CAS match-fixing jurisprudence emphasizes that mere suspicions of betting or poor performance alone cannot meet this threshold. There must be persuasive evidence of intentional participation in the manipulation. Now here, in contrast, FIFA relies on, firstly, a betting pattern report by Genius Sports, and secondly, anonymous evidence we have already challenged under Issue 3. Now, the Genius Sports report evidences suspicion, not manipulation by Fortuna. The Genius Sports Integrity Report explains that its performance analysis is based on, quote unquote, our opinion only, and that the report is designed to highlight incidents for further investigation, not to assert that any individual is definitely involved in impropriety. This can be gleaned from Exhibit 1 under the Performance Analysis Introduction. Now, on the betting side, the report identifies abnormal pre-match and in-play betting in favor of Cometland and notes that bookmakers suspended markets shortly before Cometland's first goal. However, unlike in Orkiov and Pobeda, no link is shown between the bets and Fortuna. No evidence he or anyone connected to him placed or facilitated bets. No financial trial, and no communication with the betting syndicates. On the performance side, Genius highlights several errors, such as the misjudged lofted pass leading to the 0-1 goal and the earlier handling mistakes. But crucially, Genius explicitly states it is not suggesting any individual is definitely involved in impropriety and that it's only in their opinion. The report also records that Iridonia was statistically superior earlier in the match, with 68% possession and more shots on target. However, CAS match fixing cases require more than bad mistakes in a suspicious game. They require intent, derived from a solid evidentiary chain, which is missing in the present case. Therefore, we conclude that Article 20 has not been breached. And if members of the tribunal have no further questions, I end my submissions.
Thank you.
Thank you. Good morning, honorary members of the panel. My name is Brandon Zhang, and I am with my co-counsel, Maxwell Peter, and we appear on behalf of the respondent, the Federation International de Football Association, FIFA. I will speak for 10 minutes and respectfully reserve 1 minute for rebuttal. Members of the panel, this case is about upholding the integrity of the sport of football, and in principle, sanctions and compulsory cooperation for fact-finding is essential to maintaining the image and the integrity of the sport of football. There is no place for corruption and the manipulation of match fixing. I will speak on two issues. First, a procedural issue on the appellant's statement of appeal, and the second issue, the substantial issue of the appellant's refusal to hand over the phone. I now begin with the first submission. We submit that the statement of appeal filed by the appellant is not admissible for two reasons. One, the time of the receipt of the decision shall begin on 31st May, as the appellant had the opportunity to obtain the knowledge of the decision. And second, even if the panel takes the day of receipt to be the 2nd of April, it still falls outside of the statutory 21-day limit. On the first point, members of the panel, author Rigozzi Hasler in Aruro Manuel's book, Arbitration in Switzerland, states at page 498 that it suffices, according to standing jurisprudence of the CAS, that the addressee had the opportunity to obtain the knowledge of the decision. Whether or not the addressee had actual knowledge of the content is irrelevant. In the present case, the decision was fully upheld on 31st March 2026. At that particular time, if I may direct the panel's attention to paragraph 23 of the record, the appellant had stated he had now hired legal counsel on 8 December 2025, and therefore his legal counsel would have had on 31st of March the opportunity to obtain knowledge of the decision, knowing fully well that they were also at the time under investigation by FIFA.
Counsel, I have a question. Wouldn't you agree that with the appellant that it will be more plausible for the appellant to file his appeal after knowing the full decision? Because it will definitely make more sense, like for him to know what grounds he's appealing against.
Yes, member of the panel. According to CAS case jurisprudence, in the 2015 CAS decision GFF versus FIFA and SVGFF, a letter qualifies as an appealable decision only if it affects the legal situation of the addressee, i.e., if it contains a ruling. And if I may direct the panel's attention to Exhibit 7, paragraph 8, there that decision shows that there was a sanction for match manipulation with a fine of CHF 100,000 and a 5-year ban for all football activities in accordance with Article 20, subsection 1 of the FDC. And therefore, it does contain a decision with a legal ruling and affects the legal situation of the addressee, Mr. Member of the Tribunal. And on the second point, members of the Tribunal, we submit that the exceptional circumstances that the appellant raises is not applicable to our case. Article R56 of the CAS Code requires that the exceptions require that the party was objectively prevented by extraordinary circumstances. And it is our submission that, one, the circumstances are not exceptional, and two, that even if they were considered to be somewhat circumstantial, that does not prevent the appellant from it. The inconvenience of such were not of a nature to prevent the appellant from complying with the deadline. In our case, at paragraph 5 on paragraph 30 on page 5 of the record, the mere reference of the appellant's email servers that had, I quote, recently been subject to an attack, I quote, which may have disrupted outgoing emails without necessarily generating delivery error messages. This cannot be the basis to request that the CAS reinstate the deadline for the filing of the statement of appeal for 3 reasons. First, there's no actual confirmation of the actual date or relevant time period which the cyber attack took place. Second, there's no confirmation whether there was any disrupted outgoing emails. And lastly, even if there were outgoing emails which were disrupted, it did not necessarily mean that the delivery error were not generated. On those bases, we submit that the case is not exceptional, and accordingly, that the statement of appeal is inadmissible.
Counsel, just one final question. You did mention that it could be possible that the error messages could have been generated and they could have acted upon it. But at the same time, it could be very well that they had sent the email, but the error messages, because of the cyber attack, prevented them from even knowing that the email was not being sent. And then in this respect, couldn't this be said to be unforeseen because they do not even know that their email was sent or not sent?
Yes. Members of the tribunal, the CAS panel has held in the 2009 case Qingdao Zhongnun FC versus FIFA at paragraph 66 that under such circumstances, the club was not required to request the grounds of the appeal decision, and the failure to ask for the grounds is therefore not detrimental to the club's appeal. And CAS jurisprudence has emphasized that this is a strict and absolute, that the time limit for filing an appeal is absolute and strict, and that there is no discretion provided under the code to extend the time limit for filing a notice of appeal. For example, in the 2015 decision of Fawcett Kimberly Smith versus ITU, the panel at paragraph 53 held that as the appellant did not comply with the deadline for filing the appeal, the court accordingly held that the appeal is dismissed and inadmissible and expressed no opinion on the merits of the claims. If there are no other questions, I will move to submission 2. Pursuant to FIFA Disciplinary Code, Article 12, subsection 3, this requires that an athlete cooperate to establish the facts of the case when requested to do so. And accordingly, in the present case, at paragraph 20, the appellant immediately refused to cooperate repeatedly when FIFA's representatives requested the appellant submit his mobile phone for the purposes of the investigation. Despite having nothing to hide, the appellant has chosen not to cooperate and not submit his mobile phone on 2 accounts. And in light of the evidence, such as the exhibits 4 and exhibit 3, the emails and WhatsApp messages shows that there was contact between the appellant and the appellant's father exchanging messages with a member of a criminal group involved in match fixing. As well, the witness stated that he heard the appellant talk to his father the night before the match. If the appellant had nothing to conceal, he would have provided his phone to the investigatory bodies of FIFA. In the 2020 CAS decision of Alexandrina versus PTIOS at paragraph 206, the court held that the appellant contrived the outcome of the match for match fixing purposes, and at paragraph 50 held that the appellant pretended to cooperate but did not do so by pretending to give her cell phone. This breached the equivalent articles of match fixing as well as the duty to collaborate. And in that case, the panel at paragraph 263 imposed a 15-year period of ineligibility. In our case, therefore, the legal consequences, we submit that the 5-year sanction imposed for match fixing and duty to collaborate is proportionate and not evidently gross. And on those bases, we submit that the refusal to cooperate breached Article 12, subsection 3 of the FDC.
On this point, counsel, I do note that the counsel for the appellant has raised Article 6 of the ECHR. What would be your response to the article?
Thank you, Mr. Member of the panel. In the context of sporting, the privilege against self-incrimination cannot simply be invoked in a disciplinary proceeding. And the question is whether the balancing of the interests involved tips in the favor of the privilege against in self-incrimination if a parallel criminal proceeding is pending or anticipated. The cooperation of individuals subject to the disciplinary rules of a sport is necessary if the integrity of the sport is to be protected. In the 2017 CAS decision of Jerome Valk versus FIFA at paragraph 226, the court provides the example, and I quote, "A fatal blow would be stricken to the fight against doping if an athlete asked to undergo a surprise doping control were able to invoke the privilege against self-incrimination, simply because it would implicate the athlete in criminal proceedings." And the court observed and said, "Thus, the danger that the result of such cooperation in fact finding may at a later point trigger a criminal proceeding is per se not a valid justification to invoke the privilege of self-incrimination." At paragraph 277 in that case, the panel held there was a violation of match fixing as well as duty of collaboration. Thank you. If there's no other questions, this will conclude my submission.
Please carry on.
Thank you, Brandon. I'll be addressing the issues of admissibility of evidence, and then I will move on to the appellant if the appellant violated Article 20 of the FIFA Disciplinary Code. I will speak for 10 minutes and I will be reserving 1 minute for rebuttal. Mr. President, members of the tribunal, for issue C, FIFA submits that both the anonymous email and anonymous witness statements are admissible. This conclusion is mandated by the FIFA Disciplinary Code, supported by the consistent CAS jurisprudence, and entirely justified based on the factual risk and corroboration present in this case. First, the FIFA's disciplinary system expressly allows the admission of anonymous evidence. Article 39 of the FDC talks about the evidence and the standard of proof, where any type of proof may be produced, and the judicial body has absolute discretion regarding the evaluation of the evidence.
Counsel, can I ask, what's the force of the FDC in the CAS tribunal?
Yes, Mr. President. So, the force of the FDC is that the CAS supersedes the FDC disciplinary code. But in this scenario, we are trying to put forward an argument that the FDC standards were not met, and thus we would like to rely on the CAS jurisprudence. So, moving on. So, the standard of proof is comfortable satisfaction and not proof beyond the reasonable doubt. This already establishes an extremely flexible evidentiary framework, especially in the integrity cases such as the match manipulation. Article 43 of the FDC talks about the anonymous participants. This provision allows anonymity where testimony may create a risk of threat and of physical danger. The judicial body may order that the person not to be identified in the presence of the parties, the person be questioning in writing, and the sensitive identifying information to be kept confidential. This case clearly falls within Article 43 of the FDC. Now, Article 44 of the FDC is about identification of the anonymous participants. The code provides a mechanism ensuring the panel verifies identity behind the closed doors while preserving anonymity for the safety. Thus, under the FDC, anonymous evidence is not only allowed, but it is anticipated, regulated, and protected. Now, turning to Exhibit C, if I could lead the panel to Exhibit 2. The witness explicitly states fear of reprisal because the appellant's father is connected to the criminal organizations. This satisfies Article 43, subsection 1 of the FDC. Second, the statement is highly relevant and reliable because witness directly observed the appellant being pressured by his father the night before the match, and the appellant shouting, and I quote, "I can't go along with everything," indicating coercion. This information directly supports the hypothesis of manipulation and explains the otherwise inexplicable behavior before the match. The Seah's jurisprudence, including the 2010 case of O and UEFA, and Seah's case, 2017 Seah's case of Secondary, has consistently held that anonymous evidence is admissible where anonymity protects safety and the evidence is a part of corroborative evidentiary mosaic. Now, application to the anonymous email. The anonymous email alleged 50,000 dodgy coins paid to the appellant's father is also admissible. Crucially, it is corroborated by the independent evidence, including Exhibit 5 of the Exhibit 5, which states that the Iridonian public prosecutors confirm that the father's dodgy coin wallet was under active criminal investigation. Exhibit 4, which states that the WhatsApp messages where, I quote, "look the crook and acknowledges receipt of the last part of the coin has been received," and Exhibit 1 of the Genius Sports report, which documents a massive unjustifiable betting anomalies and a red flag for match fixing. Under the 2017 CS case of Secondary, anonymous intelligence is admissible if corroborated by objective indicators such as betting patterns, financial movements, and performance anomalies. This is exactly the situation here. This is not a normal sporting dispute. This match triggered a red integrity alert. The bookmakers worldwide suspended the markets in real time, and the betting patterns were wholly inconsistent with the sporting logic. In conclusion, members of the panel, both the anonymous email and the anonymous witness statements satisfy the FIFA rules on evidence, and the CA's approach to match fixing and the requirements of the safety of corroboration, and accordingly, they must be deemed admissible and reliable. Unless I can assist any further, I would like to now move on to the violation of the Article 20.
Please move on, counsel.
Thank you, Mr. Arbitrator. Mr. President, FIFA submits that the appellant indeed violated Article 20 of the FIFA Disciplinary Code by intentionally and unlawfully influencing the match against Cometland. The cumulative evidence, betting anomalies, performance indicator, crypto payments, witness testimony, and the appellant's refusal to cooperate comfortably satisfies the applicable standard of proof. Article 20, subsection 1 of the FDC states, and I quote, "Anyone who directly or indirectly, by an act or an omission, unlawfully influences or manipulates the course of the result of a match shall be sanctioned with a minimum 5-year ban and a fine of CHF 100,000. The two crucial features of this provision apply over here. First, the indirect involvement is sufficient. The appellant need not to receive money himself, but acting under the pressure or via intermediaries still continues manipulation. And second, attempted or conspired manipulation is also punishable. A complete fix is not required. The standard of proof, as reaffirmed in the O and UEFA case and numerous integrity case, is comfortable satisfaction, higher than the balance of probability but lower than the beyond reasonable doubt. Match fixing is rarely proven by the direct evidence, but instead CS evaluates through the mosaic of indicators. The betting patterns are entirely incompatible also with the normal football behavior. Massive pre-match wagers for Cometland, despite them being the weakest team, were placed. Odds flipped dramatically in the first 15 minutes, even though Iridonia dominated the first opening phase. And multiple bookmakers suspended the markets, which is a universal sign recognized for active manipulation. the performance errors supports the intentional underperformance. According to the Genius Performance Analysis, identified repeated and numerous errors by the appellant. These errors cannot be explained by fatigue or chance. They map precisely onto the improbable 0 and 3 scoreline needed to eliminate Iridonia. The crypto payments to the father establish motive and connection. The anonymous email, which the panel will have found admissible after the submission, is strongly corroborated, as seen in the given exhibits such as Exhibit 3, Exhibit 4, and Exhibit 5. The financial link is here. The financial link here is clear, contemporaneous, and incriminating. The written statement demonstrates pressure and conspiracy. The anonymous witness observed the appellant highly distressed the night before the match, arguing with his father and stating, "I cannot go along with everything." This is compelling behavioral evidence of manipulation and pressure. And lastly, the refusal to provide phone justifies adverse inference. The appellant refused to provide his phone twice. Under Article 20, subsection 3 and Article 12 of the FDC, the duty to collaborate is strict. An unjustified refusal to provide relevant evidence, such as a mobile phone, may permit the judicial body to draw adverse inference. The CS has recognized both the duty of cooperation in the establishing facts and the possibility of adverse inference in non-cooperation cases, including UCI and Contador. In the case of UCI and Contador, given that the typical match fixings is coordinated via WhatsApp and Telegram, this refusal strongly supports the conclusion that the appellant was concealing something incriminating in the communication applications. Mr. President, members of the tribunal, when the evidence is viewed holistically, the betting anomalies the repeated performance errors and the crypto transfers and the refusal to cooperate shows that the conclusion is inescapable. The appellant did manipulate the match and violated the Article 20 of the FDC. Thus, we would like to submit that the appellant did violate Article 20 of the FDC. Unless I can assist any further, Your Excellency, Mr. President. Thank you very much. I would like to submit my argument.
Mr. President and members of the panel, one point in rebuttal. Earlier, counsel for the respondent has alleged that the cyber attack is merely an inconvenience that prevented the appellant from filing the statement of appeal. And in respect of this, we disagree. This is a cyber attack that clearly goes beyond a mere inconvenience. It has prevented us legal counsels from being able to file a statement of appeal to the CAS. This goes beyond simply saying that it was inconvenient for us to do so. Rather, it was truly an impediment that was unforeseen that prevented us from doing our jobs. And ultimately, because this impediment was unforeseen, reinstatement should be granted to allow the statement of appeal to be recognized by the CAS. Unless I may be of further assistance on this issue, this concludes my submissions. Thank you.
Mr. President, just give me one moment, please. Mr. President, 1 point in rebuttal. The panel in the 2019 decision PFC Live versus UAFA at paragraph 89 held that inconveniences were not of such a nature to prevent the appellant from complying with the deadline, and I quote, in particular, the official holidays during the deadline of appeal, and the inconveniences when sending the documents by courier were not of a nature to prevent the appellant from complying with the deadline, and held that statement of appeal to be inadmissible. And in our case, there's 2 points. One, it has still not been proven 100% the relevant time, and in fact that those emails were affected. And two, cast jurisprudence, as the case I just mentioned holds that an inconvenience or such a circumstance does not warrant a reinstatement of the appeal. On those bases, we submit that the statement of appeal is inadmissible. Thank you.